Hey everybody, welcome to our training this month on bylaws. We've got CAPLAW and the Neo Law Group are here with us to provide some more information on bylaws. We've received a lot of requests for information about how to use and change bylaws. So we're going to hear from our legal experts, and I'll let them introduce themselves. My name is Lawrence Heiner. I'm the Director of Training and Technical Assistance at CalCAPA. We are your Community Action Association, and we support all 60 of the community action agencies in California. And we're happy to bring some support partners to the table to answer your questions and provide you some information. So Erin, it looks like you are first on the slide here in order, so I'll pass things off to you if you'd like to introduce yourself to the group.
Sure. Thank you so much for having me. I'm Erin Bradrick. I'm a principal at NEO Law Group, and we are attorneys for nonprofits exclusively. And we advise on the corporate nonprofit laws and the tax exemption laws that apply to nonprofit organizations. Veronica?
Thanks so much, Erin. I'm Veronica Zhang, and I'm the Deputy Director and Senior Counsel at CAPLAW. You all should hopefully be familiar with CAPLAW. We are the national partner in the Community Action Network that supports the network's legal, governance, and financial needs. And we do lots of trainings. I'm really excited that Erin's joining me today because you all in California have some pretty hefty nonprofit laws, laws in general, but and I don't practice in California. I'm from California originally, but based in Boston. And so I'm just really excited that Erin was willing to kind of jump on here and lend her expertise. Her firm really works with nonprofit organizations across the state, and they do bylaws, but they do all kinds of other things as well. And we've actually, at CAPLAW, looked to a lot of their resources when it comes to understanding some of the California specific requirements, as well as some of the federal issues that affect tax exempt organizations at large. So thank you so much, Erin, for being here with us. We are going to be tag teaming this presentation, and we're hoping that you will join us in that endeavor. If there are questions that you have or comments that you think would be helpful to share with the group, these are your peers in the Community Action Network. We are in meeting mode, and so we encourage you to either use the chat function if you have questions or comments, or to be willing to take yourselves off mute, and we'll take those comments and questions throughout. We do just ask that if you have something that really relates specifically to your organization and can be really fact specific, that we can talk about those offline, just so that we keep the presentation moving, since we have a lot of slides to get through today. So this is being recorded, and we have shared our slides with Lawrence, and he'll make those available to you all along with the recording to the webinar as well after this session today. So with that, I'll just jump in and we'll talk about, so the way that we're structuring this presentation is we're going to talk about different sections of the bylaws and issues to sort of think through, both the legal requirements as well as some practical tips as you're thinking about what your bylaws say and how you might think about changing those if you're interested in doing so, what kind of flexibilities you have. And then at the end, we'll talk a little bit about some emergency provisions that you could think about with respect to your bylaws, and also kind of tips on managing and staying on top of the bylaws amendment process. So with that, I'm just going to go right into a slide that I don't think any of you really need to be reminded of why bylaws are important, but it is helpful to think about, what bylaws are intended to accomplish. And bylaws are really the essential ground rules for how your organization will operate from a governance standpoint. When we think about bylaws, we often think about them in connection with what are known as the Articles of Incorporation, if you're a nonprofit community action agency, because those two documents tend to be sort of the identification documents for your community action agency. And bylaws, I'll say, are not just a nonprofit idea. As you'll see throughout this presentation, we identify some requirements that apply to nonprofit community action agencies, some requirements that apply specifically to public agencies, because we know that there are many of of you in the state of California, but we also talk about requirements or best practices that apply to both nonprofit and public community action agencies. And this is one of those situations where both public entities as well as nonprofit entities have bylaws. They are required for nonprofit agencies in California. They are not necessarily required under the name of bylaws, but usually public entities will have something very similar to bylaws, if not just call them bylaws, because they, again, set the ground rules for how the organization operates. And they also become kind of the, the way that actions by the board are challenged. And so that's why they're important, is that if you fail to follow them, then actions that are taken by the board at meetings or under the laws that formed your organization, those can be subject to challenge.
And Veronica, I think for nonprofit corporations in California too, it's important to note that the corporations code actually includes a bunch of provisions that apply by default if your bylaws don't specify otherwise. But then they allow a lot of latitude for an organization to really structure their bylaws in a way that makes sense for the particular organization. So putting in the time and the effort to really think through how the bylaws can be set up to really work for the organization, and investing in creating essentially a reference manual can be a really valuable exercise for most organizations.
That's a really good point, Erin. And just to focus on that point for a second, which is that it's not just a way, the rules that you want to live by, but it also sort of dictates kind of the culture that your board might want to take and how you might want to approach some of the decisions that you're making. So I think it is important to distinguish between those kind of default rules, baseline rules, as well as then some decisions, strategic decisions that you can make as a team as to how you want your bylaws to be structured. Nonprofit community action agencies, you have a chance to do this on a regular basis because your bylaws have to be reviewed by an attorney at least every 5 years. The organizational standards do not require you to adopt bylaws in a certain way. They have to comply with, of course, the federal CSBG Act, state laws, as well as other funding source requirements, which we'll talk about on the next slide. Public CAs, you are not subject to that 5-year regular review process, but it is a good idea to revisit your bylaws on a regular basis. So with that, we'll just take a look at the legal framework that bylaws for community action agencies fall within. Of course, the federal CSBG Act plays a big role in terms of what your bylaws will say, because there are specific requirements with respect to board composition, selection, and so your bylaws will reflect many of those rules. Your CAA may also receive other federal funding sources, such as Head Start, but other funding sources under HUD, federally qualified health centers also have some specific governance requirements that will impact your bylaws. Erin's going to be talking a lot about the California Corporations Code, which has, again, some of those default provisions that will apply even if your bylaws are silent on that issue, and then some parameters within which your bylaws, have to provide for certain things like indemnification and other. California has a set of CSBG rules that apply just in the state as well, both the statute and regulations, and we'll talk about some of those. The open meeting laws, we'll talk about how those apply to community action agencies. And then lastly, if you're a public entity, you know that you're subject to many of the local laws that apply to your county or city governments as well. When we're talking about organizational documents, I mentioned the articles of incorporation for nonprofit community action agencies. It's helpful to see where bylaws sit in this kind of order of precedence, what types of documents will supersede other documents to the extent that there is a conflict between the two. And you can see that for nonprofit community action agencies, your bylaws are subject to your articles of incorporation. The articles of incorporation are like the birth certificate of that community action agency. It's filed with the state. You can find it on record. It sort of announces your existence, but those tend to be fairly light. I think, is that right in California as well, Erin?
Yeah, 1 to 2 pages.
Okay, so pretty brief documents. And your bylaws then flesh out much more, the rules, the choices that your organization is making with respect to decisions. But those bylaws are subject to the articles of incorporation, and the two should not conflict. So when we talk about articles, and when you're talking about reviewing your bylaws, one kind of key thing to remember is that if you're changing your bylaws, you should also look to your articles of incorporation at the same time to ensure that you're not changing your bylaws in a way that would cause a conflict with your articles. If your board has passed additional resolutions or policies or other procedures for how you conduct your meetings, how motions are taken, how votes are recorded, those procedures are often found outside of your bylaws, but again, are subject to the overall framework in your bylaws. Public community action agencies have a similar order of precedence. There is usually a document that serves as the delegation of authority from your local government, either a joint powers of authority agreement or other type of county ordinance that establishes the community action agency. That often is, again, the sort of founding document, which gives birth to the community action agency. And then the bylaws of the tripartite board then govern the framework and the work of the board itself. And similarly, public community action agencies can have policies and procedures that the board approves and passes. Public community action agencies are not usually, they don't have unilateral authority to set those policies, and we'll talk about how they work in connection with their local governing body to pass those resolutions and policies. So we talked about this earlier, which is the point here is that you want to make sure that your articles, if you're a nonprofit community action agency, do not conflict with your bylaws. I'll see, Erin, if you have any other thoughts on kind of how articles of incorporation work for nonprofit CAAs.
Yeah, like you mentioned, Veronica, they're usually pretty sparse. They're usually, ideally, only contain the required provisions. So you can add additional clauses into your articles. And it used to be more common for organizations to do so. So we sometimes see older articles that will have provisions around board size or membership structure, things of that nature. But ideally, your articles are really stating the name of the organization, its purposes within the meaning of Section 501c3 of the Internal Revenue Code, and sometimes a more specific purpose statement. And then what's called a dissolution clause that basically says what happens if the organization dissolves and to what type of organization its remaining assets would have to be distributed. Most of those things do not then need to be repeated into the bylaws because, as Veronica mentioned, the articles will take precedence. So if there's anything in the bylaws that conflicts, what's in the articles will control. The one exception to that is the purpose statement. We will usually see that repeated in the bylaws. And what's important to note there is that the bylaws can further narrow the purposes stated in the articles, but not expand, right? So just making sure there's consistency there will be really important. And then the final point on articles is that making changes to them is more complicated than making changes to the bylaws in the sense that they can only be amended through a filing with the California Secretary of State's office. Whereas bylaws as an internal governing document can be amended internally without filing with an external corporate agency at least, although there may be an obligation to report some significant changes. So on the next slide, I think we're getting into just kind of the basics of bylaws and how they might address the power of the board. So from a California corporate law perspective, and you'll hear me mention the Corporations Code, there is a specific section of the Corporations Code that applies to California nonprofit public benefit corporations, which CAAs are set up as. So you might hear me refer to the Public Benefit Corporation Law or the Corporations Code, and those are really one and the same. It's a set of laws under California statutes that apply to nonprofit public benefit corporations like California nonprofit CAAs. So under that code, they are required to have a board. You are absolutely required to have a board that is responsible for the governance of the organization. You can use the term trustees, or sometimes we'll see other creative terms used. But when we say board, we're talking about the body of people that has responsibility for making oversight decisions for the organization. And the powers of the board, and I'm talking about the board acting collectively as a board, not individual directors, are very broad under the Corporations Code. the code basically says that all activities and affairs of the organization have to be conducted by or under the direction of the board. And that under the direction of the board piece is big because most boards are volunteers, right? Volunteer run. The board can carry out its duties as a board by delegating down management of the affairs of the organization to staff, to officers, to volunteers, to committees, right? That's very common. But the key here is that the board has to retain ultimate oversight control over all the affairs of the organization. And the board really has kind of unlimited authority to make decisions on behalf of the organization in any area, even though it can kind of delegate down management on a day-to-day basis to various people or committees. And the next slide.
So for public community action agencies, the powers are not quite as clearly delineated as they are, I think, in the nonprofit code. For public community action agencies, the tripartite board is just one group of people who are working with respect to the community services block grant program at the community action agency. But more importantly, for a nonprofit community action agency, the board has oversight over the affairs of the entire corporation. But for a public community action agency, the tripartite board really has authority just over the CSBG funded programs of that community action agency. And so that is a really key difference because you'll see that the powers of the board at a public CA are much more limited. So the powers will depend ultimately on the authority that has been delegated to that board by the local government. So if your community action agency sits at the county level, if it's part of a county department, then it depends on what the delegation of authority agreement or statute or ordinance gives to that community action agency board. We should expect to find somewhere in that delegation of authority some description of what the board's powers are, as well as any limitations. So if decisions are subject to ratification by the local governing authorities, or if there are certain powers that the board is not authorized to undertake, then that should also be found in that delegation of authority agreement. The California CSBG statute does have some specific parameters for what public community action agency tripartite boards ought to be able to do. And it specifically notes that the board can be either advisory or administering. That's nice because in some states, tripartite boards are only advisory, and so they're only authorized to make recommendations to the local governing authority or to the board of that local governing authority. But in this case, California says that public community action agency boards can be administering, which we think is more aligned with the Federal Community Services Block Grant Act's language, which charges the board with administering the community action program at the agency. Of course, what does that mean? That means providing at a minimum input on the community action agency's activities to the local government officials. So again, they're responsible for overseeing the community services block grant program at the CAA. The California statute also says that boards, may participate in the process of selecting the executive director of the community action agency, so long as local laws don't prohibit doing so. So even though the board of a public agency may not have, again, unilateral authority to hire, supervise, and terminate an executive director of the agency, there should be, for public community action agency boards, some mechanism of participating in that process. And then the statute says that public community action agency boards may have authority, if it's delegated to them, to do a number of other things, including setting the board's own rules and procedures. Oftentimes those may be within the larger framework of the county's rules for the boards of county or city, again, depending on where your community action agency sits, the bodies that govern those counties. The board may also be delegated authority to select its own officers and to set its own executive committee. It has a role to play in approving and reviewing personnel, fiscal, organizational, and other programmatic policies. That's subject to ratification by the local designating official of your organization. But you should also see something in the delegation of authority or in the bylaws for the Public Community Action Agency Board, the ability to approve either program proposals, budgets, subcontractor agreements, again, subject to the ratification of the local designating officials. So as you can see here, for a Public Community Action Agency, the power of the board is really dependent on another party's approval, usually the local designating official. However, we always advocate for public community action agencies to empower the board to take, at least to make recommendations, if not to administer the community action agencies programs in a way that gives them some voice in the decision-making process. All right, moving to the topic of how big should our board be? I think if we were to ask that question here, there probably would be a range of responses. Under the California state CSBG requirements, your board has to be between 12 and 30 members. That number, the total number of directors on the board, has to be divisible by 3 to meet the tripartite requirement. So these are specifically stated in the statute. For nonprofit entities, well, maybe I'll let Erin jump in on this point here since it's relating to the corporations code.
Yeah, so the code just says that the bylaws have to have a provision around the number of directors, and that provision can either specify a set number, it can specify a range of permissible number of directors, or it can specify a method by which the number of directors will be determined. By and far, the most common provision we see in bylaws is a range of number of directors. So the bylaws might say, this board may have between 12 and 30 directors, with the authorized number of directors from time to time to be established by resolution of the board, right? And then it might, for CAAs, include an additional provision specifically mentioning the divisible by 3 requirement. And then the board has the ability to set the authorized number within that range from time to time as appropriate based on the number of current directors.
Erin, can you speak to why you would recommend or why you typically see a range as opposed to a fixed number of members on the board?
Yeah, it's just for flexibility. When we see a fixed number, if the organization has directors unexpectedly resign, right, it's actually no longer in compliance with its bylaws and needs to be constantly recruiting to try to get up to that number. Whereas if you have a range, it gives the organization some flexibility to grow or shrink the board as appropriate from time to time without needing to amend the bylaws.
Yeah, I think that's a big piece that we also emphasize is, especially we saw during COVID times, if it was difficult to have a board the size of, that you had said in your bylaws, if you didn't provide for a range in your bylaws, then you actually have to go through an amendment process to change that, as opposed to having the board determine a number of directors on the board within that range allowed in your bylaws simply by resolution of the board. In terms of the composition of your board, this is, again, largely driven by the federal CSBG Act, and the California CSBG rules mirror those federal requirements. That composition is set forth here, which I think most of you are very familiar with. It's the 1/3, 1/3, 1/3 concept. It is nice to see that you have some flexibility even within this tripartite composition requirement. Exactly 1/3 of your board has to be made up of public officials. Those are either elected public officials or appointed public officials if elected officials are not available to serve. You need to have at least 1/3 of your board be made up of what we refer to as the low-income sector, and we'll go into how you select folks in this sector. And then the remainder of the board is made up of private sector individuals. So when we see, when we see the composition of the board, I think one question that comes up very naturally is who selects those members of the board. And this is, again, a way that community action agencies are different from a lot of other nonprofit entities as well as local government boards, because it depends a little bit on the sector of the board that you're talking about. But the overall thrust is that the Federal CSBG Act requires board members to be chosen by the eligible entity, the community action agency. For public CAAs, the Community Action Agency is the department or office within a county government, city government, within a local government structure. And so generally speaking, the governing officials of that local government will have ultimate say over who will sit on the board. However, we think tripartite boards should and do make recommendations to the local governing officials as to who should sit on the board. And again, the bylaws will dictate some sort of process around how those folks are selected and then recommended to the local governing officials. For their nonprofit community action agency, the board is ultimately the one that chooses members to sit on the board. And even though the federal CSBG Act has procedures around who selects someone to represent them in a particular sector of the board, we always recommend that community action agencies, nonprofit community action agencies, have their board take a vote to seat each board member after meeting those sector-specific selection procedures. And we can talk about how this sort of works in practice as we move through each of the sectors. But this ensures that when it comes time to remove board members, that the board has the authority to remove members that even if they are chosen as a representative of someone else. And then lastly, the federal act requires that the low-income sector of the board be selected through a democratic selection process, which we'll talk about as well. But so let's talk first about the public sector of the board. As I noted earlier, if there are not enough elected public officials who are available to serve in this sector, appointed public officials may also serve. Public officials don't have to serve themselves. They can designate a representative to serve in their place on the board. In that case, it's the representative who is the board member and not the public official who made that designation. So that's important to remember as well. In California, the public officials who can either sit on the board themselves or designate a representative, those public officials have to be currently holding office. This is more specific than some other states require. In some states, the public official just has to be in office when they make the selection, but if they later leave office, their designee can continue to sit on the board. In California, that's not the case. The public official must be currently in office, currently holding office to sit on the board himself or herself, or to designate a representative in their place. And that really aligns with the federal guidance from the Office of Community Services. In an information memorandum, it recommends that public officials serve only while they're in office. And if you think about the intention behind the tripartite board composition, it's to reflect the current interests in the community, the elected officials, the low-income sector, as well as the private sector. And so having public officials serve only when they are currently holding office just aligns with that. For nonprofit community action agencies in the public sector of the board, should specify that if the public official designates a representative, that it's the designee who gets to vote on issues, and they are the board member, and they are the one who owes fiduciary duties to the organization. And you have the most flexibility if you don't specify which public officials get to designate a representative to your tripartite board. So we see this sometimes where community action agencies say, the Board of County Commissioners for this county can select or can designate 3 people to serve on the board. That's one way to do it, or you can leave it fairly broad in your bylaws and just say elected public officials within the Community Action Agency service area are entitled to select 4 members to the public sector of the board, but not designate which public officials have to be the ones to choose a representative or serve on that board sector. This is in case you have a Board of County Commissioners that is not being collaborative and isn't choosing someone to serve in your sector, or is refusing to sort of, take that responsibility. You're not stuck being out of compliance with your bylaws.
And Veronica, can I just add a point on before we move on?
Yeah.
It's really important to note that on the fiduciary duties point that Veronica mentioned, regardless of how someone ends up on a nonprofit board, once the individual is serving as a director, regardless of how they got there, whether they were designated, elected, they serve in their individual capacity and as an individual owe fiduciary duties to the organization, right? So including the duty to exercise independent judgment, to make decisions they believe to be in the best interest of the organization above the interests of any other entity that they're affiliated with or individual that they're affiliated with. So really important distinction there.
Yeah, and I feel like that's a point of confusion often, especially with this sector, because sometimes the elected public official sees themselves as being the board member, even though they've designated a representative. And so the representative is more just an agent for a proxy for that elected official. And I see Erin shaking her head, which is that is not the case.
Not from a legal perspective, yes.
That's right. And it's important for both the designee as well as the local official who's choosing a representative to understand that point. And it should be a part of the conversation that you're having with the local governing official as they're designating a representative. For public CAAs in California, appointed officials can include employees of state or local agencies or boards, so long as that individual has authority to decide and carry out the policy of those agencies or boards. So it does not technically need to be an official or an elected or appointed public official. For the low-income sector of the board, this is the group that has to be democratically selected. The federal CSBG Act, as well as the California requirements, make clear that these folks are supposed to be representative of low-income people in your service area. The intention behind this sector is to give the communities that are served, that are receiving the benefits of community services block grant funding, a voice in the decision-making process of that agency. The rules are also very clear, however, that those individuals do not have to be low income themselves. So it's not just clients who need to sit on the board, it's representatives of the communities served by your organization. And so the process that you use to select those representatives is in some ways up to the agency to decide. And we typically recommend that your democratic selection procedures are not in your bylaws, again, because the bylaws are meant to be sort of more general rules for the organization, more difficult to amend in certain cases, more notification requirements, but you have your democratic selection procedures written in a separate policy that is referenced in the bylaws, but can be sort of changed outside the bylaws amendment process. Those procedures should also be approved by the board. So how do you go about selecting low-income sector directors? We could do an entire presentation just on that. But what I'll say is that there are different methods that are permitted, and CAPLAW has resources that talk about how different agencies within the Community Action Network have gone about selecting low-income sector representatives. The California CSBG statute refers to area representatives as well as non-area representatives. And these are really just about who gets to select the person who then sits on the board. If you're using the area representatives process, then residents of the area, all residents of the area, select the representatives to sit in this sector. There are requirements about, the number of low-income folks who are voting, and that being proportionate to the number of low-income folks in the community as a whole. But the idea is that residents within a target area or neighborhood are doing the selection. In that case, the person who is selected must be a resident of that area. If you're going with the non-area representatives process, low-income individuals in your entire service area can select those representatives. It doesn't have to be limited to residents of a particular neighborhood or group. And then the ways to go about selecting these folks, there are kind of two primary ways of doing so. One is to have the Community Action Agency itself hold an election. So either you have a ballot box that you're setting out in your offices, and you have people who are eligible to vote in that election drop off ballots, or you host a community forum or other gathering where you have nominees for a position on your board, and then you conduct an election to select representatives. That's the sort of direct election method where the Community Action Agency is running its own election. Separately, you can have what we call a micro-democratic selection process, which is when you have groups representing low-income folks. in your communities select a representative to serve on your board. And so an example of this would be if you have a Head Start program and your Head Start Policy Council, which is made up primarily of parents of children in your Head Start program, if they select a representative to serve on your board, that also meets the requirements of the federal CSBG Act. So in addition to Head Start Policy Council, you could have tenants organizations, community health center patients, if you're a federally qualified community health center, or other sort of neighborhood associations, so long as you can make a connection to that group and how they represent the interests of the low-income community. Again, for nonprofit community action agencies, if you're selecting someone to represent a specific neighborhood or area, so that neighborhood representative process, then the person who is chosen must live in that neighborhood that they're selected to represent. You can have, however, at large representatives, which is that non-area representative process. For public community action agencies, all low-income board members must live in the service area. So even if they're not representing a particular neighborhood, they have to live somewhere in your service area. We've seen this come up, especially when you have someone who used to live in the service area, but who has moved out of the service area. That can be tricky for community action agencies, because in that case, depends again on how you've worded your bylaws, but there may be a residency requirement that would force that person to resign from the board. The last sector is the private sector. This is a sector that tends to have the most flexibility for community action agencies, because you can select individuals who represent a number of different interests in your service area. There's just a list that's included here on the slide, but you can basically designate any kind of group or interest in your community to have representation on your board. Again, our recommendation is that your bylaws don't specify that, you know, this faith group or this school or this particular you know, Chamber of Commerce or bank have a representative to serve on your board. You have more flexibility if you allow your organization to designate the groups on an as-needed basis. I just want to mention briefly the Head Start board composition rules. I know that not every community action agency has Head Start, but many do. And so if you do, there are additional board composition rules that apply, and these should also be reflected in your bylaws. If you have a Head Start program, you have to have at least one board member who has financial expertise, quote unquote, that is not defined. And so agencies have flexibility to, you know, select someone that they believe has financial expertise, but you do need to track that for Head Start monitoring purposes. You also had to have at least one member who is a licensed attorney who is familiar with issues that come before the board. This one sometimes can be a difficult one to meet, especially if they're you don't have a licensed attorney in your area. Some CAAs are very rural and so don't necessarily have someone who fits in this category. But as you'll see at the bullet at the very bottom of this slide, if the board is unable to find someone who fits these requirements, the board can choose to work with someone on a consultant basis. So rather than have a licensed attorney sit on your board, if you are working with an attorney who has familiarity with early childhood education expertise, or you know, early childhood education, then that would also meet this requirement rather than having a board member who meets those qualifications. And then lastly, you need to have someone who has early childhood education you know, experience and skills. And that usually is an easier one to meet for Head Start agencies. Other board members ought to reflect the community. And so we see, you know, CAAs meeting that just through the tripartite requirement. However, you should try to ensure that you have current or former Head Start parents on your board as well. Oftentimes CAAs meet this requirement by having the Head Start Policy Council select a parent representative who serves on the governing body of the board. I think, again, for these folks, it's important to remember that fiduciary duty concept, which is that they, you know, they owe a fiduciary duty to the organization as a whole, even though they're selected to represent the policy council, they're not just on the board to talk about kind of Head Start, early childhood education matters that come before the board. They really need to be engaged in all the business that comes before the board. Another issue that trips up folks a lot is the requirement that board members and immediate family members of those board members may not be employed by the community action agency. Head Start has a fairly long list of what it means to be an immediate family member, and that includes in-law relationships, which means that you cannot have a board member who has an immediate family member who is working, who is on the payroll of the organization, even if they're not working with Head Start. So that's just a really important thing to keep in mind, because sometimes if you don't ask that kind of question in your board application screening process, you sometimes have no idea that there is a familial relationship between an employee and a potential board member. And you really want to know that before the person gets on the board, before it sort of comes up, down the road, and you have to look into either removing that board member or terminating the employee, both of which are not great choices for your agency. Head Start has a strict prohibition against financial conflicts of interest with a board member. And so unlike for a lot of, the general kind of conflict of interest rules where organizations can follow their conflict of interest policy and allow for, disclosure of a conflict, recusal of that board member from the discussion involving the transaction that has a conflict, but the board can sort of still move forward with that transaction if the rest of the board believes that it's in the best interest of the organization to do so. If you're a Head Start grantee, no board member can have any financial conflict of interest with the agency, which at a very simple level means that you can't be doing business with an organization, a business that a board member has a financial stake in. And so again, this is something that can trip up Head Start agencies as well. This should be in your conflict of interest policy, and often we see this built into bylaws as well, just as a reminder for board members of these agencies. This also means that board members cannot receive compensation for serving on the board. In the community action world, you all know that board members are not paid. We don't have employees of community action agencies sitting on community action agency boards because of that prohibition. I'll let Erin take the piece about nonprofit alternates here.
Yeah, and I think, Veronica, it's great that you're flagging some of these areas where the corporations code might permit something, right? So it might permit a transaction with an entity in which a director has a financial interest, or it does permit compensation being paid to directors. But as a CAA, there are these additional layers of laws, going back to that first slide with, the multiple boxes that CAAs are subject to, and sometimes more restrictive than what the corporations code might permit. Alternates, though, are an area where the corporations code will come into play for nonprofit CAAs. The law says that no matter what your bylaws say, there's no such thing as an alternate director, right? So under the corporations code, there are directors, period. And either you are a director or you are not a director. And if you are a director, you have the right to vote on every matter placed before the board, assuming you are present at the meeting at which the matter is being voted on. So you cannot vote by proxy, meaning you can't ask another director who's present to cast your vote for you. And you cannot vote by alternate, having an alternate attend the meeting on your behalf if you're unable to attend. We will talk a little bit more about attendance at meetings being permissible by phone or electronic video screen communication. So there are ways to attend, and I'm sure everyone is well familiar given the last 2.5 years that we've all experienced. There are ways to attend meetings, through telephone or video screen and still be considered present in person for legal purposes. And the only distinction here I'll just note is that the code does permit alternates for committees. So not for the board itself, but if the board creates a committee, the board can designate alternates to serve on that committee where a member of the committee isn't able to attend. So that's distinct from the rules that apply to the boards themselves.
And then for public community action agencies, the rules are a little bit more flexible. The state CSBG laws do allow public CAAs to permit alternates to vote when the primary board member cannot attend. And so this is the idea of choosing a representative to serve in the public community action agency board's absence. And that's ultimately, even though you're permitted to do that, our recommendation tends to be along the lines of the Nonprofit Corporations Code, which is that you want to make it clear who owes a duty to the community action agency and to the board. And when you allow for alternates, sometimes those roles get a little bit muddled and you don't know who is the one who's really serving on the board. And if someone can attend, they feel like they can just have an alternate attend in their place. And so our recommendation is even for public CAAs that you have designated who is a director and who is not a director, and then only the directors cast votes at meetings, and you hold those board members accountable for absences from board meetings. Petitions for board representation is, again, a kind of a unique wrinkle for community action agencies. The federal CSBG Act requires that your agency have procedures in place that allow for groups who feel like their interests are not adequately represented on the board to petition for board representation. We generally see these in the bylaws referenced very generally. It doesn't necessarily set out, what exactly goes into that process, but you do need to permit a process for doing so. All right. I don't see any questions, so I think we'll move on to board terms and term limits. And so here we're going to tag team a little bit. So for the state CSBG laws, as well as the federal laws, are silent as to board terms. They don't have anything to say as to whether terms are required and what they should be. So maybe I'll let Erin talk first about the nonprofit community action agencies.
So as Veronica mentioned, in California, we tend to have fairly complicated and expansive laws. So we don't have a lot of silence on anything if we're talking about California nonprofit corporations. So for nonprofit CAAs, directors do have to serve terms. They cannot serve for an unspecified term length. When they are elected, they need to be elected for a specific term length. That term can range from 1 to 6 years for organizations that do not have voting members, but 6 years is the maximum. I'd say most often we see 2 to 3 years as kind of the norm for most organizations. The bylaws should specify what the term lengths are for directors. And we'll talk a little bit about staggering, I think, in another slide. So there are ways in which you can have directors serve different initial term lengths in order to implement staggering, but the bylaws should say what the normal kind of term length for a director is. The corporations code says that if the bylaws don't specify, then the default is 1-year terms, meaning that you'll be holding elections every year if your bylaws don't make clear how long the terms are for directors.
Which can be pretty administratively taxing. And so you definitely don't want to fall into that category unless you have chosen 1 year as the term that you would like to set for your directors. Public CAs don't have the same requirements, so then there's no term requirement. There's no requirement that you have board members serve a specified term. And for both public and nonprofit CAAs, you can stagger terms. And we'll talk about that a little bit more in the next slide. We do recommend for both nonprofit and public CAAs that you do specify the board terms. You're required to do so for nonprofit community action agencies, but that you do so for public community action agencies as well. And you can set different term lengths for different sectors of the board. And we often see this for public officials, the public sector of the board. Remember, those public officials can only serve so long as they're currently holding office. And so that essentially, you can have a term length with that caveat, which is that if someone leaves, if a public official leaves in the middle of their term, then that person is, no longer eligible to be serving on the board. And that includes their representatives as well. And so you can choose different term lengths for different sectors. That's something that you have to keep in mind if you want to manage, but you can choose to do so. I see a question from David, and you also have your hand raised. So I'm thinking it might be the same question about term limits. Is there a limit to how many terms they can serve? So you read our minds. That's the next slide. And so we'll get there, David, if that's okay. But let us know if there's other parts of your question here. In terms of talking about how to set up staggered terms and what that means, Erin, could you tell us a little bit more about those?
Yeah, so the corporation's code specifically says that boards can implement staggering by assigning directors to groups. And the idea with staggering is that if you have maybe a third of your directors, let's say 3-year terms, a third of your directors elected in 1 year, a third of your directors elected in the next, and a third elected in the third. That ensures some continuity of governance and leadership across the board so that you don't have all of your directors kind of terming off at the same time. And this becomes particularly important if you do have consecutive term limits that we'll get to on the next slide. So the most common thing that we will see is the use of group 1, group 2, group 3 is appropriate. And then we'll see when directors are elected, they're assigned to a particular group, and that group will be elected, at every second, third annual meeting of the board, depending on how long the terms are. And that director will serve until their group is up for re-election, right? So the initial term might end up being shorter, but the staggering allows for really kind of efficient maintenance of the composition of the board over time. It can be a really helpful tool.
Great, thanks. And then I think one more piece about board terms before we get to term limits for the public sector of the board. It mentioned that, in California, the public official has to be currently holding office. We still recommend having terms. And again, if you're a nonprofit corporation, you still have to have a term specified for public sector directors. But you don't just have board members serve so long as the public official is holding office. In some cases, if you don't have term limits in that office, then you could have people serving in their office for a long extended period of time, and you may not want that for your board.
I should also clarify, Veronica, too, just because I realized they didn't state this very clearly, but the required term length for directors applies to elected directors. If your bylaws do have a process that allows some individual or entity to specifically designate, so really just choose the person who sits in that director seat, then you're not required to apply a term limit to a designated director. So that requirement will apply just to elected.
Erin, can I ask, and so this is an interesting wrinkle, because for many community action agencies, a group will designate a director to sit on your board, but we have always encouraged community action agencies to then take a vote for their boards to take a vote to seat that person on the board. So in that case, would you say that that person is elected still to the board?
So I debated whether we should get into this because we were talking about it earlier. So it's going to depend on what your bylaws actually state, right? So in order to give another entity or individual the right to designate a director, your bylaws need to explicitly state that. So if your bylaws say, this identified organization can designate one director to serve on our board, they can apply a term to the designated director. They can set parameters around who's eligible to be designated. So you can include quite detailed provisions in those designator provisions in the bylaws. Then an election technically isn't necessary because it's the designator that has that selection right. They also have certain rights under the code with respect to removal or replacement that the bylaws can do something with in modification, but there's certain core rights in the code. But depending on how your bylaws are drafted, if it's more of an input process, right? So this agency can select somebody to recommend for election to the board or nomination for election to the board. But the way they actually get seated on the board is by election by the board. That's not a true designation right within the meaning of the corporations code. So it's really going to depend on how the bylaws are structured and what they explicitly state.
Got it. That's really helpful. Of course, California would have a rule about this.
Yeah. We're one of the few states, I think, that actually allows for this true designation provision. So it is a bit complex.
Got it. And so just to clarify, for directors who are designated to the board, there is no board term requirement.
There's no requirement, but your bylaws can still choose to implement a term, right? So for most CAAs, I think it would probably make sense to have terms, even if the same individual is then designated for subsequent terms.
Okay, great. Okay, let's move on to term limits. And David, you'll let us know if we answered your question. The federal CSBG Act and state laws are silent for both nonprofit and community action agencies. There is no limit to how many terms a board can serve. That doesn't mean that you should not or cannot choose a term limit to include in your bylaws.
And this is one area where there's consistency with the Nonprofit Corporations Code. So it's also silent, meaning that the organization can choose to impose consecutive term limits in its bylaws, but there's no inherent requirement that it do so.
So how do you make that decision? I think this slide gives you some of the benefits and drawbacks of board term limits. And Erin, please feel free to jump in as you think of these as well, or your experience working with nonprofits. What we've seen with term limits, and we often recommend term limits at CAPLAW because we think that it ensures some sort of regular turnover of board members. I know not every nonprofit or public community action agencies sees a regular turnover. And so in some cases, if you have long-term board members that, you're looking for new ideas and new energy, this is a sort of diplomatic way of having board members who have served for a long time step down from the board. And it also allows for others to kind of be added to that decision-making process at the board. I think some drawbacks are, of course, there's a loss of institutional knowledge when you lose board members who have gotten to know a community action agency's programs, its operations, sort of how it functions, because boards don't meet very frequently throughout the year. It can be hard or it can take some time for board members to settle into their role and really understand the agency. And so having term limits that are quite short can be difficult for the agency to manage. It requires more frequent recruiting, especially if you have a process like the low-income sector democratic selection process. It may require the board to be constantly engaging in recruitment efforts for board members. I don't know if you have anything else to add here, Erin.
No, I agree with it. I think this is one of those issues where there's no right or wrong answer, and it really just depends on what makes the most sense for the particular organization. I do, a few just tips. I do recommend against very short consecutive term limit provisions. So we usually will see limits that are closer to 9 or 10, 8, 9, 10 years of total service rather than on the kind of 3, 4, 5 side, just to allow for some flexibility and continuity across board leadership. The other point I would just make is that I strongly discourage provisions in bylaws that say if you have consecutive term limits, that there's an option for overriding that with respect to a particular director. The reason I discourage that is that politically speaking and relationally speaking, that can cause a lot of drama when the board chooses to exercise that option with respect to one person and not with respect to another. It can create situations where there's pressure to exercise that option, which defeats the purpose of the consecutive term limit in the first place. So if you're going to have them, I'd say have them. If you're not going to have them, then gives you a lot more flexibility.
Great. In the interest of time, I'm going to keep moving, but again, if you have questions, feel free to put those in the chat. Let's talk about removal and resignation provisions. So these should also be included in your bylaws, both the reasons for removal as well as the procedures for doing so. So I'll let Erin take the Nonprofit Corporations Code piece.
Yeah. So the code says that a director may be removed without cause. And again, we're talking about elected directors here. So the rules are a little different for designated directors if you have true designation provisions in your bylaws. But an elected director can be removed without cause by the vote of a majority of the directors then in office. So slightly higher standard than is required for most board actions. The code is actually silent about removal with cause, interestingly. So it doesn't actually specify by what standard a director may be removed from a board with cause. And the code also says, and I'll mention that in just a minute too, the code also says that a director's seat can be declared vacant in certain situations, including if the director has been declared of unsound mind by a court, if they've been convicted of a felony, or if they're found by a court to have breached a fiduciary duty owed to a nonprofit. In those situations, the removal is optional in most instances for the board to actually take action to declare the seat vacant. And then the code also says that if a director misses a certain number of meetings that are specified in the bylaws, then the director's seat may be declared vacant and the individual removed from the board as well. So we'll sometimes see provisions in bylaws to help combat absentee directors that say, if you miss 3 consecutive board meetings, the board may declare the seat vacant. On removal of a director, we typically will see language in the bylaws that specifies that a director may be removed with or without cause by a vote of the majority of the directors then in office. And in practice, we typically recommend removing without cause in the vast majority of circumstances. The reason for that is that there's no real reason that requires you to remove with cause, even if you think there are grounds for the removal. And doing so with cause can sometimes increase risk of claims like defamation by an individual involved with the removal process, right? Comments that are made as part of that process. On the issue of resignation, I'll just note any director can resign at any time by providing notice of resignation. The resignation does not need to be accepted in order for it to be effective. It can specify a later time that it will become effective, or it can be effective immediately. As a policy, we don't try to force people to serve on nonprofit boards. So generally, it's relatively broad in terms of rights of resignation of a director. The only exception is that if you are the last director standing, you are not permitted to resign without the Attorney General's consent. So there can't be kind of a mass exodus from the board if something goes wrong.
See, we can talk about vacancies next. Or did you have another point? I'm sorry, Erin, about.
No, go ahead.
Okay. With respect to vacancies, usually you see these kind of following right after removal because, or resignation because you now have a vacancy on the board. There should be some procedures for how vacancies in each sector will be filled for community action agencies. Usually you would go through the same process as you did to seat someone to fill a vacancy. That's not a specific requirement in your state CSBG laws, which is different from some other states that has certain procedures for how you fill vacancies. So you do have a choice as to how you fill that vacancy. For the low-income sector of the board, we typically see boards repeating the democratic selection procedures or having, for example, the person who came in second in the last democratic selection process be selected to fill that vacancy through the end of that term. There is no requirement for how much time can go by before you fill a vacancy. The org standards, the CSBG org standards, which apply to both nonprofit and public community action agencies, require that boards fill vacancies according to their bylaws. We have seen state offices ding community action agencies for having long-standing vacancies on their board, which makes sense because if you have a long-standing vacancy on the board, there's a question of whether or not your board is able to make decisions. Tying this back to the piece earlier about the board size, if you do have a range of directors in your bylaws and you have vacancies and you have more than 12 members seated on your board, you can consider reducing the size of your board, again, by resolution, if you've stated that in your bylaws, so that you don't have vacancies on your board. So that's just think about how these sections kind of interact with each other. Otherwise, you're stuck filling vacancies on your board and having to go through that recruitment process. Generally speaking, the replacement director serves out the term of their predecessor, and then it's up to you to decide how you might count that partial term towards any term or term limits that you have for your board member.
And 2 quick points on that too. If your bylaws do have a consecutive term limit provision, we will often write in language that says a term of less than X amount, right? So it might be a fraction of a term, or it might be 1 year, specified in actual term length of months or years. Doesn't count for purposes of the consecutive term limit. And it's in part to allow for this situation where maybe a vacancy is filled and someone serves only for 6 months of a term before they're up for re-election, and not wanting that to count as a full term for purposes of a consecutive term limit. And then the other thing I would just note on filling vacancies is that we sometimes see really creative language in bylaws around how vacancies can be filled that gives a particular officer or a committee the right to fill a vacancy. And that is not permitted under the Corporations Code for nonprofit CAAs. So generally the position needs to be filled in the way that the position was originally filled. If that was by election and by the board, then the board would need to fill the vacancy. Can't be delegated down. So in terms of board meetings, this is another thing that we'll usually see quite a bit in the bylaws about how board meetings are called, how they are chaired, any rules as to frequency. In terms of frequency, there is not actually a required frequency in the Corporations Code for how often a board needs to meet. As a best practice, we generally recommend a minimum of meeting quarterly in order to ensure the directors are staying really in touch with what is happening at the organization and can meet their fiduciary duties and exercise appropriate oversight, but that's not a legal requirement. The law, the code does not actually require that formal notice be given for regular meetings of the board. So regularly scheduled meetings of the board, including the annual meeting. But the bylaws can require that a notice be required for those meetings, even if it's not required by law. So that becomes an organizational preference point. Some organizations choose not to require notice in their bylaws so that there's one less procedural requirement that they are subject to compliance with. And for others, that formal notice requirement is a really important part of ensuring that directors are really aware of when these meetings are being held. So again, not a right or wrong answer, but important to look at what your bylaws say, because you can move away from what the law requires. For special meetings of the board, on the other hand, where it's not a regularly scheduled meeting of the board, it's being called because there's some particular action that the board needs to look at between board meetings or on an urgent basis. For those special meetings, the code does require formal notice to be shared with directors, and the bylaws can't do away with that requirement. So a distinction between kind of regularly scheduled meetings of the board and special meetings of the board that are called unexpectedly. The notice for board meetings, whether it is for a special meeting, so required, or whether it's for all meetings because the bylaws require it, does have to specify when the meeting is going to be held, obviously. It should specify where the meeting is going to be held, although the code says the default is at the principal office if the notice doesn't specify another location. And then it should specify whether there is a means of participating in the meeting through telephone or electronic communication to the organization. Our code is fairly antiquated, so it still refers to facsimile and other things of that nature. Electronic mail, it doesn't use the term email. It certainly does not contemplate things like Zoom or the various tools that we have available in the modern world to facilitate meetings. So sometimes we run into some weird situations where the law doesn't quite mesh with our current way of practice. But meeting notices, when they are required, may be sent electronically. So you could email out the notice, assuming formal notice is required. But there's a caveat here, and it is that the code, because it is antiquated, it says you can only send meeting notices or other communications electronically if you have the prior written consent of the director to receive electronic communications on file. So we will typically draft these consent forms for electronic communications and encourage them to be used as part of the onboarding process for any new director, so that it's just there and it's on file and organizations can operate how organizations operate in today's world. If this is something your CAA doesn't already have in place, I'd highly encourage you to do it now and just have it kind of in your onboarding process built in from here on out. And then the other thing we sometimes get questions about is whether the notice of a meeting needs to specify what's going to be addressed at the meeting. And it may, there's nothing that says it can't, but it's not strictly required. And there's nothing that limits a board from addressing other issues at the meeting that are validly raised, even if they weren't listed in the notice. So no real requirement there as to what will be addressed at the meeting. Board members who do not receive formal notice for whatever reason can waive that notice requirement They can either waive it formally through signing a waiver of notice, or they can waive it by attending the meeting and not protesting the lack of notice at the beginning of the meeting. So kind of default waiver of notice. If you are ever calling a special board meeting and you're going to be addressing something particularly controversial, sensitive, really important, and you're not sure if you gave notice in compliance with the requirements of the code or in your bylaws, getting this waiver of notice for any directors who weren't able to attend the meeting can be a good way to just kind of button up the procedural aspects of the organization's affairs. I'm seeing a question about a format for a waiver of notice. Yeah, we could probably share something. I'll make a note of that and try to follow up after.
Great. Thank you so much, Erin. That's a really good tip too. I know not all states have requirements like that. So maybe it's possible that community action agencies haven't thought about this in a while.
Yeah.
Moving on to open meeting requirements, I think a perpetual question for community action is, do our meetings have to be open to the public? If you're a public community action agency, the answer is yes, absolutely. The state open meeting laws apply to you because you're a part of that local government. And as to whether you can conduct meetings that are subject to the open meetings law, to the Brown Act, via Zoom or other teleconference, that will then depend on, what your state open meeting laws permit, and especially if there are emergency procedures around what is allowed during this time, during the pandemic as well. I know many states waived or changed aspects of their open meeting laws temporarily for the public health emergency that we're still currently in. For nonprofit community action agencies, our read is that the Brown Act does not apply technically to your organization. You're not created under local government laws. You're designated as community action agencies under California state law, but you are not created pursuant to those laws. Many community action agencies, we've been told in California, do comply with it as a best practice or voluntarily choose to comply or to hold open meetings. Our recommendation in that case is that you don't voluntarily subject yourself to all of the provisions of the open meeting laws in your state. There may be a desire to have your meetings accessible to the public, and you can say that your meetings will be open to the public without requiring that all of the procedures of the Brown Act apply to your meeting. And that distinction is really important, because once you say that you're subject to the Brown Act in your bylaws or to the open meeting laws in your bylaws, then you've got to follow that those rules to a T, and those can dictate when and whether you can go into executive session, for what reasons, what the procedures would be. And oftentimes that is that goes much further than just having your meetings accessible to the public, that you've posted notice of your meetings in public places like your website or on your social media pages or in your local paper, for instance. And you can meet that spirit of having your meetings open to the public without having to go through all of the requirements of the Brown Act. So that is our tip for California nonprofit community action agencies. If you have voluntarily committed yourself to the Brown Act, or if you're a public CAA and you are required to do so, then there are certain practices that you may not be able to follow, such as probably conducting a unanimous consents in lieu of a meeting. So this is when directors vote on a matter via written consent. So by signing a document that indicates the action that is going to be taken by the board without actually holding a meeting, that is not permitted if you are required to comply with the open meeting laws. And your ability to meet via teleconference and phone is then dependent on how your state open meeting laws have been interpreted to allow those procedures.
So looking at a quorum requirement, right? And the quorum is the idea of what percentage of the board or how many directors need to be present at a meeting in order for us to consider enough to be present for the meeting to happen and business to be carried out. And the default in the corporation's code for nonprofit CAAs is that a majority of the directors then in office constitutes a quorum. And this is the standard we most often see. Most organizations do not choose to veer from this default requirement, but it is permissible in the bylaws if you'd prefer for a different quorum requirement to apply. The minimum that is required is 1/5 of the authorized number of directors. So that's the very minimum you can have as a quorum. We very rarely see organizations go that low for, obvious reasons of wanting input across the board for decisions to be made by the board. And a great point Veronica added to the slides here is that when you state your quorum requirement in your bylaws, really important to make sure you're saying equal to, not at least, right? So using precise language about the number of directors that actually equals a quorum. And one other thing I'll just mention, because we'll sometimes see it play out. If you have a quorum present at the beginning of a meeting, and then directors have to leave the meeting early, even if you don't have a quorum at that point, you can actually continue with the meeting under the corporation's code. The requirement, though, is that any actions that are taken from that point on still need to be passed by the required threshold, assuming a quorum was present, right? So we'll talk about voting in the next slide. So this kind of segues us into that conversation. So the default standard in the code as well is that a majority of the directors present at a meeting at which a quorum is present need to approve an action in order for it to be considered by the board. And that is, again, the standard that most organizations will apply in their bylaws to pretty much every action of the board, except that it is possible to apply a higher threshold for certain actions of the board. So we'll often see that in amending the bylaws. Sometimes we'll see a higher threshold for amending the bylaws that's applied, or sometimes for the removal or election of directors, we'll see a higher threshold. The idea being that there might be certain decisions that you want greater consensus amongst the board for the board to actually take. But that's a choice that the organization can make by how it writes its bylaws. There's also a few things in the corporation's code that just by default require a higher threshold of approval rather than just a majority present at a meeting with a quorum. That includes what we call self-dealing transactions. So transactions where a director has a material financial interest. For the reasons Veronica mentioned earlier, that's not likely to be relevant to CAAs, right? Because the additional restrictions they're subject to on those types of transactions. And we also have a higher standard that applies to transactions with another organization where one of your directors is also a director. So these are called common director transactions. And then finally, the creation of board committees. So these are committees that are authorized to act on behalf of the board. Most often we see it in the form of an executive committee. The creation of those committees or appointments to those committees need to be by a higher threshold, and any decisions around indemnification of directors require a higher approval threshold. But the default is approval by a majority of the directors present at a meeting at which a quorum has been established.
Erin, can I ask, in terms of the requirement to have the higher threshold for the creation of an appointment to the executive committee, as you said, the committee that is authorized to act on behalf of the board, does the corporation's code specify what threshold it has to be?
It's a majority of directors then in office.
Oh, got it. Okay.
So I think these sometimes are helpful to play out in numbers, right? So if you have 13 directors on your board, right? So the minimum required for the CAA range, a quorum, let's say, is a majority, you'd have to have at least 7 show up at the meeting. If something requires approval of a majority of the directors present at the meeting, and say 7 show up, so you just meet that quorum requirement, that means 4 of the 7 could approve it, right? So 4 out of 13 could technically approve an action on behalf of the full board. But if you have this requirement that applies by law or just by the bylaws, that a majority of the directors then in office approve something, that means at least 7 out of the 13 have to approve the action, regardless of how many showed up at the meeting, right? So if it's only 7 at the meeting, all 7 have to approve it to meet this higher threshold. So sometimes I think taking these concepts and applying it to the actual numbers really helps illustrate how the different standards end up applying in reality.
Great. Thank you so much for that.
So just talking a little bit about how boards vote, how individual directors vote in the nonprofit context. So each director gets one vote on every matter placed before the board. We already said that there's no such thing as directors voting by proxy. There's also no such thing as director breaking a tie on the board. It's one vote per director present at the meeting, right? And I mentioned earlier that a director can generally attend by phone or video. There are some specific requirements in the code, but they're fairly easy to meet. So if you're going to hold a board meeting in either entirely telephonically or by video screen like we're doing right now, either entirely or just for a few directors who aren't able to attend in person, then the rule is that every director in the meeting needs to be able to hear one another throughout the entire meeting. So again, fairly simple standard to meet. Alternatively, if you're going to use other electronic means, and this is again where the code is a little old and it's not so precise in terms of what that means. So it's anything other than telephone or electronic video like we're doing on Zoom. So if you're using a chat function or some sort of electronic polling, then the rules are a little bit different. You have to actually have a setup that allows every director to communicate with every other director present in the meeting concurrently, and for every director to interpose a comment, an objection, or a proposal as part of the meeting. So holding a meeting and using the Zoom chat function is going to be a little bit trickier, whereas a method that allows actual conversation that kind of mimics an in-person meeting, so telephone or video, there's more flexibility under the code provisions. And I'll just briefly mention unanimous written consent, and I know Veronica mentioned this. So this is an area where we hear a lot of confusion. There is no such thing permitted for nonprofit boards as voting by email. So you cannot send around an action and say, let us know whether you approve or not of this action, whether your vote is yes or no. And then if a quorum comes back to you with a vote and a majority says yes, consider that to be passed. Boards can only take action through a meeting at which a quorum is present or unanimous written consent. And unanimous written consent is different than a vote by email because it is only considered passed. An action is only considered passed when the very last director gives their written consent to that particular action, right? So it's not a vote. It is if every single director consents to this action, we will consider it to have been adopted by the board. It does have to be in writing, but the code doesn't really specify what in writing means. So we will sometimes see email used as a tool for a director to provide their written consent for purposes of unanimous written consent. We do recommend, if you're using unanimous written consent for something rather significant or where you're going to have to demonstrate the approval to some third party, to another external agency or to a bank or something of that nature, that you actually type up resolutions in a Word document. You email the Word document around, ask directors to print, sign, scan, and email the PDF back, rather than just sending an email that says, yeah, I approve. Right. So really depending on kind of the nature of the decision that is being made using this tool. But we get a lot of confusion around this, can we hold votes by email piece? So important to understand that distinction.
And a really big piece is that it has to be unanimous. And so you cannot have a single director fail to respond. Even if they wanted to respond, but they didn't respond, that doesn't count either.
No consent by silence. Yeah, absolutely.
I know we're running short on time here, so Erin and I wondered whether we would get through all these slides, but clearly we may not. I think
lawyers can talk for a long time.
We really did. This slide, we've actually covered the content here, so I'm just going to go ahead and skip it. You will have access to all of these slides after this presentation, but we've talked about all of the points here. We have talked about committees as well. And again, many community action agencies are familiar with the idea of committees. And so we won't spend a lot of time going through it. I think the kind of key piece that I'll say is typically the only committee that is designated to be able to take action on behalf of the full board is your executive committee. You may have other standing committees outlined in your bylaws, like an audit committee or finance committee, a personnel committee or an HR committee, a nominating committee, which all are really important, but those the decisions of those committees are always recommendations to the full board, and then the full board has to take action to either adopt that recommendation or pass some other action. The executive committee, however, is charged with being able to make decisions on behalf of the full board. And we saw executive committees really useful during the pandemic when you couldn't necessarily gather a quorum of your entire board. Your executive committee could meet in between board meetings or meet in lieu of your board to be able to commit the agency to certain decisions. You should have committee charters, is what I'll say, to outline the responsibilities of committees. And it's a really useful tip for engagement of board members to have each board member serving on at least one committee. Erin, I'll see if, do you have anything to add with respect to the California code?
So the code has one sentence about these other committees, right? So there's an entire section about board committees that are authorized to act on behalf of the board and a lot of requirements that apply. And then it has literally one sentence that says the board can create such other committees as it deems appropriate. And those committees can have directors and non-directors. So you have a wide degree of discretion in how you set up those committees. My only practice point would be strongly recommend placing provisions around those other committees in separate charters rather than in the bylaws, so that you have more flexibility to make changes as appropriate over time. So on the officers piece, from a nonprofit corporate law perspective, you are required to have at a minimum either a president or a chair of the board, or you may have both, and then a secretary, and either a treasurer or a CFO, or you may have both. So those are the absolute required minimum officers. And then the board has discretion to have such other officers as it deems appropriate for the organization's affairs. And then a piece to note under the Corporations Code, the same person may not simultaneously serve either as secretary or treasurer and as president or CFO, or excuse me, chair of the board. So the same person can serve as secretary and treasurer at the same time, but whoever is filling either of those roles can also be in kind of the CEO, president, or chair of the board role.
Some other kind of provisions that you see apply to board members, like terms, term limits, removal, resignation procedures, vacancies, and how you fill them. They're sort of parallel for officers too. So you're thinking about, if you needed to remove an officer and you needed to fill a vacancy in an officer position, how you would go about establishing that. And for the most part, the choices for these are up to the community action agency to decide. This next, go ahead.
The code doesn't require terms for officers, unlike directors, but we still strongly encourage having them in the bylaws, just to ensure some sort of turnover and clarity around when a term ends. It can be really awkward otherwise. So we would encourage adopting term limits for officers, even though it's not required.
And those can be different from the terms of the directors as well.
Yeah, we often will see that.
This is just a sort of a chart that specifies a relationship between the board and the executive director. There's not a requirement to include this, but we have seen many community action agencies choose to do this to sort of spell out the role of the executive director and the board. This is for nonprofit community action agencies. Of course, for public agencies, the choice of the executive director, the board may have some input in, but does not have ultimate authority over. For compensation, again, the simple, answer is board members cannot be compensated if they're serving on community action agencies, which means that you will not see an employee of the agency serving on the board. However, board members can be reimbursed and often are and should be reimbursed for expenses that are incurred while they're performing duties on behalf, as part of their board service. And so there's some kind of wrinkles here where officers cannot be compensated for professional services that they're providing to the organization. Again, if you're a Head Start grantee, that would never be the case because there can be no financial conflicts of interest between board members and the agency, but it's just something to keep in mind that's under the uniform guidance. And your board should have some policies around expense reimbursement for travel costs. If you seek to have other sort of perks for board members, such as childcare during a board meeting or food during a board meeting, those should also be spelled out in that separate expense reimbursement policy.
And the key there is reasonableness, right? So the example we say is like a pizza party for a board totally fine. A pizza party in Italy, where you fly everyone there, probably problematic, right? So reasonableness and common sense. On this slide, I'll just note, and can we keep going for a few minutes since this is being recorded? And if anyone needs to drop off, we won't be offended. So we'll get through just these last few here, maybe. So for approving expenses, we will usually see something pretty brief in the bylaws that refers to how expenses can be approved by the organization, but we strongly recommend for most organizations a separate expenditure authority or signing authority policy that really says who within the organization is authorized to commit the organization financially and in what way. We'll sometimes see that tied to a budget and certain deviations from an approved budget needing approvals, and or we'll see it divided into kind of buckets or tranches. So maybe an expenditure below X amount can be approved by a senior staff member, an expenditure above X amount and below Y amount needs to be signed by 2 people or approved by another officer, and maybe expenditures above Y amount require additional board approval. So having that policy that's really thought through and clearly written down can be a really helpful tool. Indemnification. So this is it's a complicated legal concept, but the idea of it is that certain people, if they incur damages or costs or expenses in connection with their service to a nonprofit as a director or an officer or another agent, then there may be situations where the organization indemnifies them or makes them whole for those expenses, those costs, those damages they incurred as a result. And this is an area where the corporations code has complex provisions that say that there's certain circumstances where the organization is required to indemnify an agent. Usually if that person ends up being successful on the merits of a claim in a lawsuit. There are certain situations where the organization is prohibited from indemnifying, so it can't use organizational assets to make the person whole. So it's usually if they're found liable, right? So if they committed the wrongdoing that they're accused of committing, unless the court determines otherwise, or if they settle an action, right? So if they don't see it through to resolution of the claim on the merits. And then there's some situations where indemnification is permissible. So it's allowed, but it is not required. And that is the one area where your bylaws can actually make a difference, because most of these provisions in the code apply regardless of what your bylaws say. They just apply. But your bylaws can expand indemnification rights for directors and officers by making it mandatory for the organization to indemnify whenever the law permits it, right? So it's that third category where indemnification is permissible but not required that your bylaws can impact. And that, including that language in the bylaws, is something that can be a helpful recruiting tool. It provides more protection for directors and officers of the organization. And then a big piece of that is also maintaining directors and officers insurance to ensure that you actually have assets available to comply with any indemnification obligation the organization may face. The takeaway on indemnification is if you are ever in a situation where you're considering indemnifying, call a lawyer first. This is one of those areas where getting legal counsel in advance of board decisions is going to be appropriate and important.
And it sounds like also in the process of reviewing your bylaws, if you haven't had an attorney looking specifically at the indemnification provisions for how they sort of map onto the California requirements for nonprofit corporations, that would also be a good idea.
Yeah, we tend to see one of two ways. We see either a really short section in the bylaws that just refers to the code, or we see a kind of a copy and paste of the full code provisions into the bylaws, because you don't have a lot of flexibility there. So it doesn't really make sense to try to craft your own language around indemnification.
I think we just have this section on emergency provisions and then a couple of tips on managing and staying on top of your bylaws left. If maybe we can try to fly through these a little bit. Yeah.
With us. So from a corporations code perspective, these were added relatively recently. So there's language in the code that says in the case of an emergency or in anticipation of an emergency, the organization can do some things that we wouldn't normally allow it to do. So it can modify its lines of succession in terms of who has decision-making authority over the organization. So that might apply to like who the designated CEO is and who's next in line. If the CEO is incapacitated, you can modify that line of succession. You can also provide notice of meetings for the board in any practical manner. So we loosen up some of those very strict notice requirements that otherwise apply to specially called meetings in particular, and possibly to regular meetings as well. You can also say that if there's an officer present at a meeting, that they are a director for purposes of that meeting in order to hit your quorum requirement. So this is the only context in which we do allow an alternate, essentially, to act as a board member. And then the code also says that the organization can take such steps as it needs to in order to respond to the emergency situation appropriately, right? But I think that's kind of a given in terms of the role of the board in general. And then finally, it gives latitude that says, in addition to these things that we inherently will allow any organization to do in the case of an emergency, your bylaws can also include additional emergency provisions around the governance of the organization, around meeting procedures that apply only in an emergency context. So we do sometimes see organizations that tack on, at the end of their bylaws, some provisions that are specifically to apply in an emergency context.
Yeah, and I think a lot of those types of provisions are kind of, some ideas in this next slide. And I won't actually spend time on this slide and the next, because CAPLAW has an entire publication that talks about building in emergency provisions. Now, that publication was not written to comply with California Corporations Code. And so if you are subject to those laws as a nonprofit community action agency in California, you do have to think about how those sort of requirements intersect. But it is sort of thinking about these categories of flexibilities that you might be able to have with respect to meetings, with respect to electing directors, especially for, selection procedures that might take more time, such as the democratic selection procedures, attendance requirements, how often and when board meetings are held. So the publication that we reference at the very end of this presentation, you'll see just a screenshot of it, cover some of those flexibilities. With respect to amending your bylaws, the requirement for California CSBG rules is that you have to submit those bylaws amendments to the state Department of Economic Opportunity before they're adopted. However, you don't need to have their approval before your board goes ahead and considers those amendments.
From a nonprofit corporations code perspective for nonprofits, they state that amendments can be made by approval of the board. So generally, when a quorum is present at a meeting, by approval of a majority of the directors present at that meeting. But the bylaws can require a higher threshold for amendments to certain portions of the bylaws, excuse me, or can set a different standard for all amendments. And then if the bylaws do say that a certain provision or a certain action requires a higher approval of the board than just the standard approval requirement. So let's say they say that amendments are required to be approved by 2/3 of the directors present at a meeting. That provision of the bylaws can only be amended by approval of that higher threshold. Right, so certain provisions of the bylaws might require a higher threshold of the board to approve the amendments. There's no particular notice requirements for proposed amendments to bylaws, but sometimes bylaws will include language that says proposed amendments have to be shared with all board members, within 2 weeks before the meeting or some specified time period. So you can write that into your bylaws, and if it's there, you need to comply with it, but there's nothing in the code inherently around particular notice related to amendments. So a few final tips for those of you who have stuck with us to the very end here around maintaining your bylaws. I know bylaws aren't typically kind of fun Friday night reading, but they are important. And I really encourage directors to familiarize themselves with their organization's bylaws, right? To really use them as a living document, as a reference manual for how the board should operate, how decisions should be made, how the organization should approach governance related matters. But because the bylaws are meant to work for the organization, it means that they may sometimes need to be tweaked, right? So on an ongoing basis, if you're noticing things in the bylaws that just really aren't working, keep a list of those so that when you do your every 5-year review, with an attorney, you have a list of the things that maybe haven't been working so well for the organization and you'd like to look at changing. And then an attorney can help you walk through how those changes might be made, what options are available. Just a practice tip in terms of working with an attorney, if you are interested in trying to keep costs down through that process, which most organizations are, I would say in my experience, the most important thing that you can do is identify a point person as the point of contact for communications with the attorney on the bylaws, rather than having every member of the board be able to pose questions and comments directly to the attorney. And similarly, limiting the number of people who are proposing line edits to the bylaws is one of the most significant things you can do in really kind of minimizing cost associated with that review process with an attorney. And then finally, there's some associations of nonprofits that you might be able to follow in order to perhaps hear from them if there are updates to the corporation's code that might impact what's in your bylaws on an ongoing basis. The code doesn't get updated very often. As I've mentioned several times, it's pretty old and out of date. So it's not that there's necessarily constantly, changes that are being made that are going to require you to update your bylaws all the time. But when there are things that, changes that are made, some of these agencies will send out news alerts that might help you kind of stay on top of them.
Okay, this is our last slide, which is just a few resources that we've got. And so you can find all of our resources online. The one resource that we make available to members at a small fee is our Bylaws Toolkit. And this has a lot of the sample language that go into community action agency bylaws that are drawn from the Federal Community Services Block Grant Act. So when you're reviewing your bylaws, the key really is to have someone both who is familiar with the Community Services Block Grant Act, the federal funding source requirements, as well as someone who might be familiar with, if you're a nonprofit community action agency, the nonprofit laws in California. If you're a public agency, oftentimes you have local counsel that you can work with within your department or within your county. So those two sort of can go together. It looks like there's one question around the requirement of an annual meeting and if you're required to have one. I'll let you take that one, Erin.
Yeah, so for nonprofits subject to the corporations code, there's not an explicit requirement that you have a designated meeting that is the annual meeting. But in most cases in bylaws, we will actually see provision saying that you'll have an annual meeting that certain things will happen at. And that's more kind of a management tool that allows you to say, this is when we traditionally hold our officer and director elections, or when we take certain specified actions is at this annual meeting. You then have discretion whether you state in your bylaws that the annual meeting will be held, on the first Monday of January or in the month of January, or if you're just silent as to when it will be held and say it will be held at a time determined by the board. So it really depends on whether you want that built-in structure or you want greater flexibility.
Awesome. Thank you so much, Erin. And all of you for staying with us and sticking through some very, I think, technical materials. We're hopeful that this is helpful to you as you think about your bylaws, and maybe this will get you excited about reading your bylaws. One can dream.
Coming up, yeah.
And thank you guys for your positive feedback as well in the comments. Really appreciate that. So maybe we'll turn it back to Lawrence.
Oh, yeah, thank you. I appreciate that. And during this presentation, our executive director, David Knight, also was able to join us. So I'll let him say a couple of words here, but thank you so much for coming in. I saw the comments as well. It's wonderful training. Really appreciate all of the information, and we'll encourage folks to purchase and download the toolkit. So David, your impressions, and everyone, thank you. Thank you all for joining.
Yeah, thanks to you both. I really appreciate it. This is going to be wonderful quality, and I'm glad we're able to record it and be able to have this information, going forward. You guys always do an excellent job, and we really appreciate you guys' partnership. I know that's something we're heavily focused on, and I know our state CSBG office is extremely focused on is beefing up our boards overall and kind of our process for that. So I really appreciate it. Are you guys going to take any more questions, or are we finished, Lawrence?
We're 15 minutes over time, so we don't want to take any more of it unless, for community action agencies in California, you can contact, me at CAPLAW with additional questions. I know that Erin talked about sharing the, sort of template for getting consent to electronic communication. So maybe we'll work with Lawrence and David and their team at CalCABA to get that out to you. But, feel free to call CAPLAW when you have questions. And when we need Erin's expertise, I'll pass that on to her.
Perfect.
And
I also-
I'm glad.
Oh, I just dropped in the chat, but for non-CAA specific, but nonprofit related questions, we also have a blog that has a lot of entries on just kind of general legal issues that apply to nonprofits, including a lot of the bylaws issues we touched on today. So if that's ever a helpful resource to any of you, please feel free to visit that as appropriate too.
It's often a helpful resource to us at CAPLAW, I'll say that. So thank you, Erin, for sharing that.
Great. Well, thank you so much for having
Well,
me.
thank you very much. This is wonderful. Yes, thank you guys. Thanks for being here. Really appreciate all you do. Talk to you soon.
Have a good afternoon, everyone.
Bye.
Thank you.
Bye-bye.